Hello, my name is Ian Larkins of Radius Law. Welcome to our monthly commercial bulletin, brought to you in association with LexisPSL. To start, we must of course mention Brexit. It's the biggest legal development for 40 years and has dominated the news for the past few months. We now have a referendum result, but ironically there seems to be more uncertainty than before the referendum, and there is still doubt on whether we will exit the EU. There are, however, some certainties. We have at least 2 years before we quit the EU, and we know that most commercial contracts will survive Brexit. There may be some uncertainty in contract where references are made to the EU, and we see a small risk that in some limited cases contracts may be incapable of being performed, where they are intrinsically linked to EU regulations. We do not see any significant shift in our current laws or future laws that are being designed to fit EU requirements. To do so otherwise will inevitably hinder those important trade deals. We will bring you updates on these topics as they develop in the forthcoming months. A recent judgment in the case of TUPE UK v Aircom Jersey 4 illustrates the importance of complying meticulously with the contract detail when making a warranty claim. In this case, the contract stated that the sellers would only be liable for a claim if the buyer gave notice of the claim to the seller, setting out reasonable details of the claim, and that any claim must be given as soon as reasonably practical and before July the 31st of 2015. The claimant, TUPE, gave notice of potential claims in February 2015 and again in June with a detailed breakdown. In August 2015, TUPE issued court proceedings, but the claims were struck out by the High Court on the basis that the notice of the claims had been inadequate. In particular, it was noted that TUPE's June letter referred to possible or potential rather than actual claims and were not specific about which warranties had been breached. Whilst this does seem a particularly harsh decision, it does provide a valuable guidance on drafting a warranty claim. On the 4th of May, the Enterprise Bill became the Enterprise Act of 2016, and the insurance provisions shall come into force on the 4th of May of 2017. Currently, insurers are under no duty to pay insurance claims within a reasonable time, leaving claimants only able to claim the sums due under the policy and interest. Under the Enterprise Act, insurers will now have to pay compensation if they do not pay a claim within a reasonable time. For commercial insurance, it is possible for the parties to contract out of these new provisions, so it will be important that businesses are vigilant and do not allow these new rights to be circumvented. Insurers will also be preparing for the third parties' Rights Against Insurers Act 2010 that will be effective from the 1st of August. This change means that where an insured has a liability and has become insolvent, the claimant companies will no longer need to prove liability of the insured or restore the insured company to the register before proceeding against the insurer. The recent Court of Appeal decision in the case of Naranda v Bradstock confirmed that deleted words can be used to interpret a contract where the contract terms are ambiguous and the deleted words help to resolve that ambiguity. Two recent cases have demonstrated that there are tools available to employers to prevent employees from stealing company data. In one case, a former employee of Acorn Waste Management emailed client lists to his personal email account before his departure, but was successfully prosecuted under the Data Protection Act. In another case, an employee moved to work for a competitor, and there was strong evidence to suggest that he had stolen a client list. The High Court made an order subject to some safeguards to destroy any confidential information found on devices belonging to the former employee or his new employer. Whilst on the subject of protecting a company's commercial interests, I would also like to highlight the Department for Business, Innovation and Skills' recent call for evidence on non-compete clauses. The call for evidence suggests that non-compete clauses can restrict flexibility on the UK labour market. We think this is a concerning development which seems to forget that there is already significant case law in this area. As always, we are keen for businesses to get involved and respond to the government's call for evidence. This is open until the 19th of July. A recent case has provided a new perspective on the rights of workers to wear religious symbols. In this case, Mazak Bita was employed by G4S in Belgium as a receptionist. After working for G4S for 3 years, Mazak Bita started to wear a headscarf to work, stating it was on the basis of her religious beliefs. G4S dismissed her and she pursued a claim for direct and/or indirect religious discrimination. Mazak Bita's claim was eventually referred to the European Court of Justice. Now, we've not yet had the ECJ decision, but have had the opinion of the Advocate General, which is usually followed by the ECJ. The Advocate General stated that as the G4S uniform policy applied to all employees, it could not be direct discrimination. The policy was capable of putting individuals of certain religions or beliefs at a disadvantage, so could constitute indirect discrimination, but determined the G4S dress code was legitimate and proportionate. Another month and another TUPE case. This time it concerns a company called Millbrook Furnishings. MFL had been a long-term service provider to the MOD. In 2014, MFL lost the contract and it was transferred to Amaryllis. Inevitably, the question then arose concerning whether MFL staff were entitled to TUPE transfer to Amaryllis. TUPE will only apply where the services have ceased to be provided by one entity and are transferred to another entity, and there is an organised group of employees whose principal purpose is carrying out the activities that are to transfer. The Employment Appeal Tribunal, reversing the first instance decision, found that TUPE did not apply as there has not been an organised group of employees. It was accepted that 70% of MFL's work had been spent on the MOD contract and that there had previously been an organised group of employees dedicated to it. However, the relevant time was immediately before the transfer, and at this time the personnel were not dedicated to the MOD contract. 2 recent cases have highlighted the need for employers to be cautious in situations where there may be a disability claim. In the case of Risby v London Borough of Waltham Forest, Risby, a paraplegic who had been employed by LBWF for 23 years, was dismissed for using racist language when he was informed that company training was being moved to a location without wheelchair access. The Employment Appeal Tribunal, disagreeing with the first instance decision, found that his reaction was linked to his disability and therefore remitted the case back to tribunal for a rehearing. In the second case, Carreras chose to reduce his previously long hours to a regular 8-hour day following a serious bicycle accident that left him with severe physical injuries. Now, this caused tension with his employer, and in February 2014, after a heated exchange with one of the owners of the firm, Carreras was told he could leave if he didn't like it. He resigned and claimed constructive dismissal and a failure to make reasonable adjustments. Now, similar to the Risby case, the Employment Appeal Tribunal disagreed with the first instance decision, stating that it had taken an overly technical and narrow approach by not finding a provision, criterion or practice that put Carreras at a disadvantage compared to his non-disabled colleagues. This case was remitted back to the tribunal. As mentioned previously, the Enterprise Act received royal assent on the 4th of May this year. Although the effective date is still to be confirmed, there are some important changes proposed for Sunday working, including decreased notice periods for shop workers in large shops, the right to refuse additional Sunday working hours, and the requirement for employers to notify their new recruits about these rights within 2 months. In the recent case of England and Wales Cricket Board v Tic-Stac, the defendants had used 8-second video clips of sporting events on their app. The ECB objected to this use and sued, claiming the clips amounted to a substantial part of ECB's works and were therefore capable of infringing ECB's copyright. The judge agreed, stating that although the clips were only very short, they were highlights and a substantial part could be considered from a qualitative or a quantitative basis. The judge was not willing to accept a fair dealing defence, as he considered that any commentary was secondary to the use of the footage itself, taking it outside the exclusion. The European Commission recently published updated guidance on the application of the Unfair Commercial Practices Directive. The UCPD prohibits business-to-consumer commercial practices that are unfair. The guidance provides some useful information on how the UCPD applies, particularly in the digital world. The CMA is consulting on draft guidance on its consumer powers. The draft guidance sets out how the CMA uses its consumer powers to address market-wide consumer problems and explains how it enforces consumer protection law. The consultation ends on the 21st of July. The Competition and Markets Authority has recently published new guidance on bid rigging and resale price maintenance. The guidance includes some leaflet-style explanations, videos and an e-learning tool. The guidance follows concerns by the CMA that competition law awareness is still very low. These concerns are arguably well founded, as 1/3 of businesses surveyed incorrectly thought that suppliers could lawfully restrict resale prices of their products. In addition, there have been some cases in this area, particularly in online sales. A fridge supplier, ITW Limited, has been fined over £2 million after restricting dealers from offering online discounts. The CMA has issued a statement of objections to Ping Europe Limited, setting out its case over the ban which prevents retailers from selling Ping golf clubs online. At the same time, the European Commission has presented its proposal to tackle geo-blocking. Geo-blocking is the use of technology to prevent a person from accessing an online service based on the country in which a person is based. There are not currently any specific laws to tackle geo-blocking, so there has been some uncertainty in this area. It is often easy to think that slavery cases are limited to less developed countries. However, recent cases have highlighted that incidents of slavery are happening now in the UK. Companies must therefore be vigilant to these risks when engaging third-party companies. In one case, a company called Chicken Catching Services was found liable for trafficking Lithuanian men and requiring them to work in unsafe conditions. Thank you for joining us for this month's Commercial Bulletin. The website details of Radius Law and LexisNexis will be shown on your screen in a moment. Please feel free to contact me if you would like more information on any of the topics covered. And if you've not already done so, you can get access to more content with LexisPSL. Please don't hesitate to contact my colleagues at LexisNexis to request a free trial. Any other feedback on our bulletins is, of course, also welcome. We'll be back next month with another update. Until then, thank you and goodbye.